Well, welcome back. Today will probably be a little more relevant for some of you than it might be for others. The focus today is on university technology, looking at it from a number of viewpoints. Were you part of the team that created it? Did the government or some sponsor pay for it? Do you want to license it? But many of the questions that are wrapped up there are also relevant to almost any time you or your company need to license or want to license somebody else's technology. Perhaps the most important takeaway from here is how important it is to recognize what both sides to a negotiation need. What are their bottom lines? They can't give those up, you can't give them up. But everything in the middle is usually open for negotiation. And the next most important thing, frankly, on any time you're doing this, is how much can you afford? Both in terms of money and in terms of limitations on whatever you can do with the technology that you're licensing. Previous sessions, we basically were looking only at a company that wanted to license, exploit technology. That was the only interest we cared about. But when a university or another research group is involved, there are at least 4 different interests. The people who invented it, whoever sponsored or paid for the work, the university, and the potential licensees who want to exploit that technology. And the university with whom you're dealing needs to recognize all of these. And recognizing these interests will help you, because the university, I hope, already understands it, what they can or will license and on what terms. So let's start off with the inventor. The inventor is probably the most important one, because let's face it, without the inventors, we wouldn't have much to talk about. Who are they? If you're talking about a university, they're students, undergraduate, graduate, postdocs, staff employed by the university, professors who run laboratories, and frankly have to go chasing the money to fund the work. What's the inventor, typically some type of undergraduate through how many years postdoc, looking for? Well, they're working in that lab to get real in-depth technology of something that's going to be of high value. They're looking for recognition, and believe it or not, a lot of them also are looking for a future job. If their group comes up with something in the laboratory they're working in, most universities will give them a share of the revenue that comes into the university if that is licensed. They want to be able to be free to use things that the university doesn't own as they go forward in their lives without being restricted. And particularly if somebody's thinking about a startup or a company of their own, and frankly it's here why they're for the license, they want to be able to exploit technologies and inventions that the university does own. Who pays? Corporate sponsors pay a fair amount of the research that goes on in most universities. The slide here will basically tell you this is how MIT, from whom I've been stealing a fair amount of this, tries to sell a corporation into funding research. You're only going to pay part of it. The US government pays more than $2 for every dollar that comes from industry. So there's a lot of financial support from other people that means your company can engage in fundamental, and look at the word fundamental because it typically is fundamental, it's not ready for market, research at a university for a significantly lower overall cost than if you had to build and maintain the same type of infrastructure in your own labs. You're going to hopefully run into talented students who are going to acquire an in-depth type of stuff They'll be of high value to you, and maybe you'll be among the really good new talent that you're going to be able to hire. And finally, and it may be ways down the list, but I don't know why it would be, you want to be able to use the technology you paid for. Generally, you can get some type of a limited, non-exclusive, royalty-free license. You also have the potential for getting a royalty-bearing license. Then there's the government. The Bayh-Dole Act is a really big deal. This was passed about, 40 years ago, and it probably has been one of the most important pieces of legislation, at least in the research and get technology out world, that's come down the pike. Before it was passed, the government spent billions of dollars in research, but practically none of it made it out. They had thousands of patents, and fewer than 5% of them were licensed. Along came Bayh-Dole with its goal of getting inventions made by the people it was largely funding in a way that they will get out, they'll be commercialized, subject to the fact that the government has to have enough rights to be able to protect the public, not let this technology fall into a deep abyss where it won't be used, and frankly, not have it be unreasonably used. At many universities, a major percentage, well over half of the research, is funded by the government. And looking at what's happened as a result of this funding, it's been more than worthwhile. In 40 years, heaven knows how many high-tech companies, hundreds of billions of dollars to the GNP, hundreds of thousands of jobs, and a lot of products that otherwise probably simply would not have come to pass. Then we get to the university. What are the university's goals? Well, the greatest university goal is teaching, scholarship, training students, and research. Those are their principal missions. Any major university is going to prioritize research and education. Teaching and research are their primary functions. Along with those, they have an obligation, an internal one and an external, to be of service to the community, frankly, the nation, and much of the world. Teaching, research, and administration and public service are essential, and they make demands. So their major goal is to make sure that technology that's developed at the university is made widely available for the benefit of the public. Research results want to be promptly and broadly disseminated. It wants to provide recognition to individual inventors, be they undergrads, people who went to work right out of a laboratory, maybe they stopped going to school when they did so, all the way up through their professorial staff. And they also somehow have to figure out how to keep the students, the faculties, the sponsors, and licensees and respective licensees happy, at least relatively happy. Probably the most important takeaway right here is that making money is way, way down the university list of what we want to do. If you're a potential licensee, you may want to make money. But what license the university is going to give you is going to focus on its goals and not on yours. Starting question that is always asked anytime I get into the subject of, gee, let's go work for a university, is who's going to own all this stuff? General rule is the university owns any IP, patents, trademarks, materials, other tangible research products, trademarks, anything that's developed by faculty, student, or staff in a way that makes some use of the university facilities and resources. Typical, it's under an agreement between the university, a company sponsor, or the government. It uses financial support from the university. And note the word indirect. This doesn't have to be direct pay, because the university indirectly provides a lot of support for things that you never see dollars change hand, but it costs dollars to provide it. And with use other than incidental, and we'll get into the question of what in heaven's name is incidental use in a few minutes, of anything, space, facilities, paper, large resources, heavy-duty computers, laboratories provided by or through, because the university has other partners, the university. Copyrights, if it meets the definition of the copyright law of a work for hire, done for you as part of your job, basically, university owns it. And typically, they have to keep owning it. They are not allowed by the government, and often by other arrangements and agreements, to actually transfer ownership of any of this IP to anybody else. License, yes. Give somebody else ownership, no. This is probably critical point number one to think about with the university. Its starting point is that unless it controls what's going on in and comes out of its laboratories, no matter who paid for the work, it creates an unacceptable to the university risk of compromising its real goals. Are there some exceptions to what they own? Yeah. The major one is there's sometimes they get funds for entrepreneurial programs, so it's much more open on that, and typically undergraduate work. So who doesn't own things? Suppose you're an inventor working in a university lab. Do you own any of the fruits of your labor? This slide is taken from MIT's policy, but the answer at essentially every other university of which I'm aware is you don't own much. Notice all of these nots. You don't own it, or you might own it if it's not developed in the course of research. It's not created as work for hire. It's not created pursuant to any written agreement, not that you ever signed, but between the university and the people likely who are paying for it. It's not developed with any significant use of facilities or fund. Well, what is not significant? Minimal amount, whatever that means, of unrestricted funds, funds that a university is basically free to hand out any way it wants to, developed completely outside of any research that if you've got a research assistantship or you're working in a lab, you have any relationship to, and you made only minimal use of university facilities, not much beyond your desk, library, the machine shop, and your own PC. And probably most important, if it was developed entirely on the personal, unpaid time of the inventor and no use of university facilities, it probably is yours. At least in most places. May not be true across the board. For comparison, look at what Caltech's student patent and copyright assignment agreement says. I'll tell you in advance that I've done some editing of these so they'll potentially fit on a slide. But this starts off about the same way that Caltech starts off saying, you know, if you generate it as a student, Caltech owns it. Notice there's no graduate, postdoc, or anything else in front of that word student. There are some exceptions, and the exceptions are about the ones you ran into on the MIT list a moment ago. The biggest one is at the bottom, entirely on my own time, and I didn't use any of Caltech's facilities other than incidental use, limited, of electronic information sources, which is very different than the incidental use that MIT permits, and not using any of their funds. And you do get to own copyrightable computer software, but guess what? Cal gets a royalty-free, non-exclusive license to use it for anything they would call educational research purposes. And if Uncle is involved, Uncle Sam gets the same type of license to use it for purposes for or on behalf of the government. We'll probably run into that phrase again, and think about for a moment what it means. For the government or on behalf of the government means anything the government does itself or anything that's done under essentially any government contract. That's a big hole for that government license for which you have no chance of any recompense. What happens when you get into sponsored research? Well, it depends to some extent on who sponsored it. If it's a government research contract, the university has an option to acquire title in any invention that's conceived, lawyer talk, thought about, or reduced to practice. Gee, let's try it out, and it really does work. Government owns it if the university exercises the option, which it usually does, but it's subject to this government license. The invention, the government has the free right to use it and use it in its behalf. And here's required to retain title. If you've got an individual sponsor, they typically provide expressly in that contract that the university owns it. But what does the sponsor get? Well, it gets a free license for internal research purposes. If you want to use this to make cars, that's not a particularly valuable if it's actually going into the car right. And then you've got the right to pick up potentially some royalty-bearing licenses if you want anything approaching exclusivity, and maybe royalty-free if you're willing only to have non-exclusive, which means the university can go out and license it also to all your competitors. Copyright is typically about the same, though it's governed much more by particular contracts than by any general ones. At least as far as the government's concerned, usually the government does not own it. It's another one of these. University owns it, but a royalty-free license to the government. In an earlier session, I talked about who owns clauses that you're likely to run into and probably have to sign when you get a job. I said then that some of them don't look like they're particularly fair. And in cruising around the web, this came up as a pretty good example. This one is really broad. It covers things you invented before you signed the agreement. Notice it doesn't tell you how long before. Could have been while you're working for somebody else, at which point you've got to be really, really careful. And while you're employed by the company, and here it's Inspire, if it pertains to any of their businesses, whether or not it's one that you have anything to do with. And this type of agreement, when you're in a disparate company with a wide range of products, all done usually by subsidiaries, that clause probably covers stuff you never even thought of. It also expressly covers, you want to do the work at home? Good luck. We still own it, whether or not they were conceived or reduced to practice, developed it at one of our facilities. Makes some of the university policies, frankly, look pretty good. So let's go and see what a university might have or be able to offer you. There are a lot of things that are developed in university research of all types that it has the potential to license to advance its basic goals. Patents, it owns a lot of patents. It owns a lot of copyrights and software. More and more important as time goes on is it has a lot of materials, both biological and metallurgical, that are developed in the universities. All of this can be licensed. Materials have a slightly different situation that often the moment it comes out of the university, you kind of look at that material, if it's your hand or a petri dish, and say, okay, what am I going to be able to do with this? So the university also typically runs into and issues situations in which it has to provide you with the material under what they call a materials transfer agreement, so that you can do some more further work to decide whether or not this is something that is worth licensing. And if so, you'll then move on to a license. Trade secrets and know-how are a little bit iffier. Universities are not designed to keep things secret. As a matter of fact, their basic mission is make it all public. There may be restrictions if you're somehow dealing, say, out at Lincoln Laboratory or here or the Jet Propulsion Laboratory in California, where you have federal security confidential issues. There may be some tied into some corporate-sponsored work where the corporation has to give the university things that it really doesn't want to make public. But as a rule, there isn't a heck of a lot in the trade secret world that is really a trade secret. Very useful. Typically, where there's a know-how license, it's kind of coupled with a patent license or a materials license, so that you buy a package that gives you not only the end product, the patent or the material, but also enough information so you might be able to figure out, what am I going to do with this? Data is a brand new subject, getting more and more important, at least it's new to me. Gigabytes and gigabytes of data. Most of it's not really protectable by itself, but that whole database is extraordinarily valuable. And universities have that, and they will license it under terms that frankly prevent its wide-scale dissemination, because otherwise it loses its value pretty quickly. Okay, in addition to these, what other types of licenses might a university grant you? One's an option. Why would you want an option agreement? Basically, you don't have your funding yet. You're not sure you're going to be able to hire the people you want. You'd like to take an option to take a license under what looks like some really hot technology, but you don't want to commit yourself until you've been able to complete a little more of your pre-work. They have sponsored research agreements. Some universities, those are carried out by an office, the same office that grants licenses going out. Other universities, there may be two different offices. If you're dealing with a university, be prepared to work, or at least know where both are, because depending on what research you're doing or where it all came from, you probably may need to know what a sponsored research agreement actually says. Confidential disclosure agreements, obviously very useful, particularly at an early stage, before anything's out, no patent application has been filed, etc. So now we move on to licensing. University has stuff to license. When and what does it want to license? What is it trying to accomplish through licensing? Go back to its original goals. It wants to make this technology widely available for the public benefit. It focuses often on parts of the economy, parts of the world geography that frankly need help. If you want to work developing something for Central Africa, for example, certainly parts of the Middle or Far East, you may find that you and the university line up a lot better in terms of, gee, this is a really important goal. Nobody's going to make that much money out of it, so it might not cost you that much. And it might give you a great deal of value in what you're really contributing to society. They want to recover some of their university licensing and research costs. Typically, a technology licensing office will try to recover what it actually pays out to people who are going to go write patent applications, et cetera, and to cover some of its own staffing costs. Their goal is not to cover research costs. The license they give you, they want to make very sure that you're going to develop and use it. Believe it or not, the goal that it make it into the economy is a university goal as much as it is yours. This can be a complete win-win. And then the university has a separate and distinct set of issues. Conflicts of interest. By its very nature, things that come out of a laboratory were developed by people who are students, grad students, et cetera, professors and staff members. Take the professor who has a laboratory that comes up with a really good commercially valuable idea. You've all known the story. It happens all the time. That professor wants to create a company. That creates an inherent conflict of interest with his or her position with the university, where she's a teacher, where she owes the university primary loyalty for a lot of things. That professor can't have anything to do with negotiating the license. There are very strict rules, and they vary some by university to university, on what happens when the professor wants to get an equity ownership in a company that he or she started. Controlled, special permissions. You'd have to get deeply into what any university I'm talking to specifically requires. It would be very useful often to the licensee and indirectly to the professor if the professor's lab, out of whom all this work comes, and it's a lab that probably knows the most about it, can continue conducting the research. At least at MIT, that's a flat no. If you own that company, the licensee, your lab cannot do any research for that licensee, as I understand it, basically, period. Your own consulting for that licensee has to be carefully controlled and reported. How many hours a week? What are you doing? And make sure it doesn't undercut. This is a very big deal for the university because its basic goal, as you recall, is education and internal for the university and the world research. Okay, the inventor wants to get paid, wants a great rep, wants a great job. The small corporate sponsor sure wants to be able to use things itself to the extent it needs to. After all, I paid for it. It would also hope to acquire both knowledge and really good people out of it. And the university wants to save the world. You want to license it. What do you want? Well, your basic goals don't really depend on the fact that the IP you're talking about is owned by a university. Going all the way back to, heaven help us, I think it was last August, our first lecture, basic goal for a licensee is still to be able to exploit the technology. What do you need to do it? You have to own or have a license to use any technology you need to make or sell your planned products. You need a market for them, and you need to avoid third-party claims. That was true when we looked at this in the beginning. It remains true now, and if the university license helps you with any of these, that is a real step forward. But what's likely to change when you license but no longer own the IP? Say goodbye to complete exclusivity. If you own it, you can say who can use it. There's always an overhead when you're dealing with a university. What about costs? You don't usually pay royalties and other fees on technology that you own. What about where do you make, use, sell? Assuming you're not infringing somebody else's patent, you can make, use, sell products that use only your own technology anywhere in the world. That might not fit a university's model for what it wants this technology to accomplish. Your patents, your patent applications. Who's in control of the patent prosecution process to make sure that the claims you get are actually useful? Who's in control of both the patents and the patent applications so that you're absolutely free to dump one if you reach the point where it becomes very clear this is throwing good money after bad? You are. You're the person who makes the decisions on who you want to sue and license. You don't have to worry about losing a license, heaven forbid, if you own the technology. But you will lose a fair amount of privacy. Because if you look at some of these sample agreements with universities, there's an awful lot of reporting, detailed reporting on sales figures and heaven knows what else that you have to provide. It's quite clear that all of these are intended to be kept confidential, but you're a lot surer of confidentiality of things you never told anybody in the first place. But there are also, even with this background, a lot of things that a university can do for you. One thing that people often forget, particularly if you're not working in a laboratory at the university or associated with one, is that a major university has an awful lot of technology that's available for licensing that you might find useful, not only to a new business, but to an ongoing one. They'll help you identify that. If you have a need for more technology in a given area, you can go talk to them. If it's sitting on the shelf and they haven't licensed it, believe me, they'd be more than willing to, provided that you can do it in a way that advances their goals. You know the technology, particularly one you hopefully know about and know something about. You've done some looking into it. TLO here, and transfer office and other places, they'll help you evaluate its patentability and commercial potential. Why? Well, one reason is that unless they think it has commercial potential, they don't want to get involved. So they have to have some idea of what is this thing really likely to do, what is its potential success. Recognize that if you're at a place like any of the major universities, only a very small percentage of the patent disclosures that come into their technology office lead to startup companies. I've got about approximately 3%. I found this in a report probably now about 5 or 6 years old, but I think about 4 or 5 major universities, Stanford, MIT, I think Chicago is on the list. It varied from about 2.3% to about 3.5%. That's not a lot. That tells you that a lot of the technology that comes out of a laboratory is not going to lead to a startup. And the university may even decide not to file a patent application. If they don't file a patent application, or they're really not interested, you may be able to license it, or even get ownership of it back. They may be willing almost to just get it out of our way on much better terms than you would if they thought it had potential. One thing to remember is universities don't typically perform either prior art searches or freedom to use analysis, freedom to operate. You're going to have to do that yourself. You may be able to get guidance, but don't count on them doing that job for you, And remember, as we talked about, I don't know how long ago, there's a real problem with prior art searches and freedom to operate. It's to say nothing of invalidity searches. The latter two are expensive, and by their very nature, it's impossible for any of them to be complete. There's just too much stuff out there. The other thing that a university licensing office can do with you is give you some insights based on their experience on what you're going to need to develop technology and actually get it to the marketplace. And they've been doing this, most of them, for a long time, and they've licensed a lot. They can help. You're going to have to come up with a business plan. But they will talk to you about it, and they will point out things that you may not have thought about. They certainly know more about potential pitfalls, particularly on things coming out of an academic startup. They also recognize that, there may be multiple licenses involved here, and that works both ways. You may need multiple licenses because they have other stuff that frankly will dominate the technology you're talking about. And they may see that as a practical matter, no single company is going to be able to do everything. So they are looking, practically speaking, there's one field that you would work well in, but somebody else with a slightly different bent and a slightly different background might be a better licensee for some other field. And the last thing that they can do for you is they all tell you, oh, there are real limits on what you can do with our name. But you can basically say, I think everywhere I've seen, gee, Caltech, Stanford, University of Chicago licensed me this development licensed me this technology. That's simply fact. And that helps your image. Helps your image quite a lot, as long as you play by their rules on how much they think you're really using it, the name of the university, honestly and properly, or do you cross their lines? More papers you have to read. So, you need to get together with the university. What's the next step? Often it isn't, oh gee, let's sign a license agreement. You may need a confidential disclosure agreement with the university, because you're going to have to disclose your potential business information, not just their technology. And disclosure of the technology can be dangerous if some stuff is still secret. Patent applications haven't been yet published. Confidential, never forget about a CDA can be useful. As a practical matter, it's only useful for a relatively limited period of time, but that period of time is important. You may want an option agreement I mentioned a few minutes ago. So you've got some time to evaluate, raise money, before you have to really put your name on the dotted line and commit yourself for the next 15 years. You may want an MTA so you can evaluate materials. I mentioned that a minute ago. From the university's point of view, it has to make sure that it doesn't have any outside obligations with respect to this technology. Or if it does, figure out how it's going to deal with them. Sometimes you get IP that two universities or a university and a company may jointly own, which means that before anything can be licensed to you, the university has to straighten that out. And frankly, you need to know how it's straightened out to make sure that it's straightened out in a way that isn't much of an adverse effect on what you're planning to do. And the last thing the university is going to have to do is to conduct its conflict of interest review that we talked about a couple of minutes ago. Some universities have sort of standard ready to sign or close to ready to sign licenses. Pre-negotiated, oh, everybody signs this, why don't you? As usual, you need to be careful with that type of offer, but it can get things going much more quickly and often in a way that works. How broadly those are available varies. Some universities offer them only for copyright, maybe software, and in some of the physical sciences. It's very hard, as you would expect, to come up with an express license that, yeah, gee, just sign it as is, because one size does not fit all. License terms necessarily depend, at least if they're going to be acceptable to you, on what's your business model. Look at this one, for example. Financial and diligence milestones to be determined. That can be a rather big deal. That tells you how much you've got to pay when you accomplish something, and by when that something has to be accomplished. How do you handle sub-licensee revenue? On the other hand, there are real advantages if you can sign one of these. It's exclusive, and you got a right to sublicense. You're going to have to look into how broad that right to sublicense is. You're not going to get stuck for what the university already paid for patent work, but you will have to pay going forward, as you always have to do. A biggie, no upfront annual or milestone fees. What do they want in exchange? Equity. If you're successful, they want to be successful too. Royalty rate 2% ain't bad. You do have an obligation to get enough funding so that they're comfortable you're going to be able to accomplish what you're going to do. And if you really create the golden goose, and a merger, an acquisition, or an IPO means you can buy any property you want in San Francisco, MIT wants a percentage of that, as does any other university, I assume, as a success fee. We helped you. We want to share in your success. But the vast majority of licenses are not, here it is, sign it, pre-negotiated. So we're going to spend the next few slides just going through the types of terms that you're likely to run into. First one is, who is licensed? Obviously, there's got to be a principal licensee, the company. What about its, quote, affiliates? And what are affiliates? Do they have to be owned by you, partially owned by you, subject to a common ownership, or what? You're also going to work often with subcontractors or outside collaborators. Those are very rarely thought of as being, quote, a licensee. You need a sublicense if you're going to be able to do with those. In some areas, you may not even get a license. You'll simply get a covenant not to sue that has some obtuse legal differences that I'm not even bothered to try to get into. You have to recognize that take it as it is. We aren't going to, MIT, Caltech, nobody is going to warrant that this technology is really going to work. Frankly, nobody will in any license they give you if they have any sense. The university is also going to want to be indemnified if you screw up, something goes wrong, people are hurt, maybe even the product fails, and somebody sues the university. That nearly always you'll have the opportunity to pay all the university costs. What about exclusivity? I mentioned this a moment ago. The university always retains rights for research and educational purposes. It would be contrary to their mission if they didn't. The government always retains rights to use an invention for it and for its contractors, collaborators, et cetera, et cetera. Corporate sponsor always gets some rights, and they may take more. Can you live with this? What's your business plan? Corporate sponsor may create the largest problem for you. Government, you're just stuck with it, but recognize there may be a lot of big government contractors who will get the contract to make the product you're trying to sell, and you can no longer sue them for infringement. All you can do is try to get some type of taking, and yet you can't even do that. You can't get anything from them. If somebody outside just doesn't have a government contract, you can go to the Court of Claims. But if they've got this government contract, they're immune from any of your people going to their door and telling them to stop. They'll just tell you to go talk to the government. You can get mixes of exclusive and non-exclusive. Often you can get exclusive for patents, but non-exclusive for other things. Sometimes you can get an exclusive to make and sell the products, but maybe non-exclusive for its use. This seems to be most typical in some of the medical fields, where you can make and sell the products, but your ability to limit who can use those products and for what is non-exclusive, because other people, other doctors, hospitals, health centers don't want to be bothered, and the university doesn't want to be in a situation where it is accused of limiting the availability of important medical technology. A license can be time limited, particularly its exclusivity. There are a lot of draft MIT licenses, and you can find some on the web, that talk about the exclusive period. It doesn't run forever. What happens when it ends? Do you at least have broad non-exclusive rights thereafter? If exclusivity ends and the license ends at the same time, you have a serious problem, and probably one you can't live with. Where are you going to do it? Worldwide, specific countries? Is your license going to be to sell and manufacture in all those countries, or is some going to be for one thing and some for the other and some for both? And I think I've mentioned before that, at least if it's under the government, there's a requirement that a product made using the invention has to be substantially made in the United States. That's worth an hour and a half all by itself, but it's a real practical business problem, because all of you know much better than I how important, from a cost point of view, overseas manufacture often is. Often a university license will be limited to a field. It's not unusual if there are a lot of broad, not particularly overlapping potential uses. You could be exclusive in one field and not in another. And some licenses actually think ahead and say, okay, you get an exclusive now, but 5 years down the pike, here's an unexpected use, and it's no part of the licensee's business. How do you and the university negotiate who then gets to try that bite at the apple? What's it going to cost? Well, 2 to 3% seems to be typical, but I've seen licenses, and actually there's some you can find online out of MIT that are 5%. One thing you really have to remember is the typical license probably covers products that aren't yet covered by an issued patent, but are simply covered by a claim of some pending application. And the usual pay is you pay if it's covered by any patent claim or any claim of a pending application, whether or not that application claim is ever likely to be granted. That's fine early on while you're still negotiating with the patent offices. But 5 years down the pike, if there are a lot of pending applications with claims that probably are never going to be allowed, in patent applications over which you have no control, should you really be paying for that? And how can you possibly negotiate? How should you negotiate? Look, just for so long, if there's never going to be a patent here, why should I continue to pay you? In the US, you can no longer challenge patent validity. A lot of licenses say, guess what? Royalty doubles if you do. There may be a minimum annual royalty, and those minimums can be fairly high. Typically, they can be credited forward, but they can be substantial. And in the early years, you may not make them. Sub-licensees. How do you deal with a sub-licensee? Do you simply pay the same royalty you would have paid, and you pay the royalty? Sub-licensee pays you, you pay the royalty that you would have paid if you'd made it yourself? Sounds fine as a starting point, but what if, let's say, the sub-licensee is selling you products at a discount to get the business, and that's part of the deal? How does that work into what you owe the university? Is there a different royalty for patents than, say, for know-how? Some cases come into play here, some legal standards. You can't charge a royalty for a patent after the patent's expired. You can charge a royalty for know-how indefinitely. So a lot of licenses will have one period patent royalty and a know-how royalty. And only the first one will run out when the patents all have run out. And the know-how one may not run out even though the know-how is now widely known. There was a case when I was just starting out in practice on the formula for Listerine. And somebody had signed a contract to pay a royalty on Listerine's formula basically forever. Well, the formula had now been public for probably 30 years, and they were getting a little tired of this. And the court told them, you signed it. Nothing contrary to law that says you can't keep paying. Sometimes you get lumped for some of the royalties. One thing you have to be careful of is stacked royalties. 2 to 3% sounds fine for one patent. Suppose you're paying 5 licensees. How does 10 to 15% of your royalties sound? What if there's more than one university patent? Do you get to pay 2 to 3 on each of those? Usually that you can negotiate and answer no up front. To keep your license, what's it going to cost you? Highly variable. Numbers I put up on the screen, and this is, again, I found just playing games on the web. From between some MIT ones are $7,500. I found one that was $100,000 a year. That's a lot of money to keep a license going unless you're really sure it's valuable. Another subject. Typically, university technology is fairly embryonic. What about improvements? It's going to be improved on. If the university continues the research, it's a particular problem because their typical license will include so-called divisions and continuations of the application that only have the original information in them, but they usually don't include continuations in part that would include the improvement. Why? They don't want to impact future research. If you're lucky, you may be able to get some type of improvement clause. Maybe future inventions made in the same lab that everything originally came out of. Maybe improvements that are dominated by the things that you're licensed and perhaps made by the same inventor. And even if they're included, are they limited to a field? Are they jointly owned? The beat rolls on. But you're always going to improve technology, and you need to be able to use those improvements. Sublicenses, critical for a business, particularly a startup where you're going to have to outsource things because you're not going to have the ability to do it all yourself. Any exclusivity, step back a second. Typically, you can only sublicense under an exclusive license. Fine, but make sure that you can. And make sure that the sublicense meets your ability to sublicense, meets what you see as your necessity for having to deal with third parties. You may have multiple tiers. We talked about the royalties. Universities may have situations in which they'll force you to sublicense. If you're not satisfying a market, or if there are perhaps some real public needs that need to be resolved, you're not doing it, and frankly, they don't see that you're likely to do. Diligence, meet your development plan. If you fail, you may lose your license. The government has the right to march in if it doesn't think and take away the license if it doesn't think you're doing anything. That happens very, very rarely, but you can't entirely dismiss it. Controlling patent prosecution is important because you want the patents you license to be directed to what you want them directed to, things your competitors are likely to do that will hurt you. University usually controls whether it's exclusive or non-exclusive. If it's exclusive, you have some, quote, rights to advise, but they don't have to take that advice because they may have broader views. Fields are particularly difficult. They will always control, the university will if it's fields, because different people may have different ideas as to what claims. How good will the claims the university wants be compared to what you want? How do you work that out, and how much you pay? Particularly since you're going to pay for all this patent prosecution. And it's very, very difficult, it can be big, to control the costs. Same deal. If you own it, you can sue. If you're licensed, who can sue? It varies. Some situations, universities take the view that only we have the right to sue, but you can sort of require us to do so. Some, if it's exclusive, will say you have the initial right to sue, but if you screw it up, we can come in. But even if you got the right to sue, the university typically has the right to get involved in and has to approve any settlement, which can make settlements much more difficult. And they may have different views, different rules, if the infringer sues first. What's called a declaratory judgment action. Somebody's afraid you're going to sue them, so they sue the patent owner, which, remember, is always the university. Say, I don't infringe and your bloomin' patent's invalid. You won't have the right, or anything approaching a controlling right to sue, if your license is non-exclusive or you've got a limited field. Finally, what happens if you want to transfer the license as part of your business plan? A lot of agreements say, some say, no assignment of any type, direct or indirect, without our advance permission. That will not help your business negotiations with a potential purchaser of your company. Another that's much more usual, particularly when you get a license from a corporate entity, is if you have a division or a group and you're selling off that whole group and all the licensed business goes with it, that you can assign. How long is the license going to last? Probably as long as the patents do. When can it be terminated? Well, nearly any license can be terminated for breach. That's dangerous, unless you have a realistic agreement provision in that license that gives you a realistic amount of time to cure the breach. Before you sit down with any licensor, and not simply the university, these are questions you need to think about. Some of them will also come into play when you're thinking about getting a license from somebody else, from the other person, from a different viewpoint. Starting point, particularly with university, as I said, it's very early, most of it. It really is preliminary, groundbreaking research. And it's going to be very hard to figure out X years in advance how long is development going to take, and how's it really going to be commercialized, in what market and what products. Have you really thought through your business and development plan? Do you have enough funding to get to commercialization? You probably have a technical team, but how's your management team? A lot of companies rise and fall in the management team, and among other things, keeping both management and marketing very closely aligned and in communication with the technological team. If those start separating, things do not go well. You mentioned somebody's got to conduct a prior art and freedom to operate analysis. Particularly if you want somebody else's technology, you want to have to pay for things. People don't want to pay for things that are just going to cost them money when somebody else sues. What other technology will you need? What other licenses will you need? Technology you can develop. Licenses, that assumes that somebody else has it. What can you afford? And what kinds of limitations in a license, a university license, are consistent with the way you see your business going? Do you really need a worldwide territory? Do you really need all fields? Looking back to your patent portfolio, do you need patents throughout the territory? My usual answer is absolutely not. And that is a great big sinkhole into which you can pour a great deal of money for very little return if there is not a real chance of a competitive manufacture or substantial competitive sales in a country, typically a fairly small one. Why do you want to spend money on patents? If you have a patent, for example, in Germany, France, Switzerland, and the UK, do you need one in Liechtenstein or Belgium? Probably not. Can you meet the development milestones that a university is going to require? And they're basically required to by Uncle Sam. Can you live with limited exclusivity? And do you have a type of product where you really can substantially manufacture it in the US? Well, these questions are really what the last dozen or so sessions have really been about. Your technology, whether you own it or licensed, is what's going to enable you to make and sell product in a significant market. The question throughout these whole lectures has been, okay, how can your IP, owned or licensed again, help you to do so? This is the last slide of the last session. I've had a lot of fun doing this, and I've actually learned a lot. I hope it's been useful for you. And as you see these, people will always tell you through the boot camp or anywhere else how to get back if you have more questions. Good luck.